Good evening, and welcome to tonight's webinar, which is a practical approach to pre- and post-marital agreements. I'm Siân Smith, and with me is Krishma Patel. We're both barristers in the Financial Remedies team at 42BR. This is the sixth session in our current family law series. All the other ones are on our website, so you can have a look at those at any time. During the course of the talk, if you do have any questions, please feel free to put those into the Q&A box. And if we have time, we may deal with some at the end of the session, or otherwise we'll ask you to follow up by email. We'll put our email addresses up at the end of the webinar. After the webinar, maybe tomorrow, you will get an email with the recording, the slides, and a feedback form. And so if you complete that, that would be really helpful for webinars to come. So Krishna is going to kick us off talking about marital agreements. So I will hand over to her.
Thank you very much, Siân. Hopefully you can all see the slides, which are about to begin. So marital agreements. So effectively, the first slide just introduces nuptial agreements. The first type is prenuptial agreements. And what is that? That's effectively an agreement that's made between two individuals before their marriage has taken place. It normally sets out how the couple wish their assets to be divided between them if they later separate or divorce. Post-nuptial agreements are the same, so a legal agreement between individuals, but the difference here is that they are already married. The agreement again will normally set out how the couple wish their assets to be divided between them if they later separate or divorce. And some post-nuptial agreements also detail how the couple currently arrange their finances and how this will either continue or change during the marriage or separation. Normally, within nuptial agreements, you will find details surrounding agreements between matrimonial and non-matrimonial property or joint and separate property, including assets acquired during the marriage and assets held in joint names, such as the matrimonial home and joint bank accounts, and non-matrimonial property, which will usually be things like assets owned before the marriage, inherited assets, or perhaps gifts received by one party during the marriage. Now, before the case of Radmaker that was decided in 2010, that's on the final bullet point in this slide, it would often be argued that prenuptial agreements were contrary to public policy and the sanctity of marriage in that they encouraged divorce. But that changed in the landmark decision of Radmaker, which we're going to look at now. And the facts of this case are that Miss Radmaker was a German heiress who married Mr. Granatino, who was a French banker. They married in London after signing a prenuptial agreement in Germany 3 months earlier. The agreement provided in the event of a divorce that neither of them would benefit from the property of the other. They separated after 8 years of marriage, and at that point, Mr. Granatino was working as an academic, earning about £30,000 per annum. And he applied to the courts for financial relief. Now, at first instance, the court awarded him just over 5.5 million to enable him to buy 2 homes and to provide him with a capitalized income for life. The court looked at the prenuptial agreement and considered it was of diminished importance, particularly as Mr. Granatino had not had legal advice on the agreement. But Miss Radmaker appealed this decision, and she argued that the prenup should be given decisive weight. She was successful in her appeal, and then Mr. Granatino then appealed to the Supreme Court, where his appeal was unsuccessful. In its judgment that was handed down in October of 2010, the Supreme Court confirmed by a majority of 8-1, with Baroness Hale dissenting, the Court of Appeal decision that there were no factors that made it unfair to hold the husband to the terms of the prenuptial agreement. And the Supreme Court in that case considered the weight that should be given to a nuptial agreement when exercising its discretion under Section 25 of the Matrimonial Causes Act 1973. And at paragraph 75 of that judgment, the Supreme Court held the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless in the circumstances prevailing, it would not be fair to hold the parties to the agreement. And so it concluded that Mr. Granatino should be bound by the terms of the prenuptial agreement, even though he wasn't fully appraised of the means of his wife at the time he entered into the agreement, and despite not having the benefit of legal advice at the time. The key question that came out of Radmaker in terms of prenuptial agreements is what is fair? And the Supreme Court in that case emphasised the cases of White versus White, Miller and Miller, and McFarlane versus McFarlane, which established that fairness is informed by the three principles of need, compensation, and sharing. It outlines that the court going forward will need to consider what may be fair or may not be fair. And fairness can be assessed by applying the three-stage test effectively that's set out in paragraph 75 of Radmaker, which is A, the agreement must be freely entered into, B, the parties must have a full appreciation of the implications of the agreement, and C, it must be fair to hold the parties to their agreement in the circumstances prevailing. So looking at Part A, which is the agreement must be freely entered into, paragraph 71 and 72 of the judgment provides some guidance in relation to this. So 71 says that the first question is going to be whether any of the standard vitiating factors, duress, fraud, misrepresentation, etc., are present. Even if the agreement, it says, does not have contractual force, those factors will negate any effect the agreement might otherwise have. But unconscionable conduct such as undue pressure, falling short of duress, will be also likely to eliminate the weight to be attached to the agreement, and other unworthy conduct such as exploitation of a dominant position to secure an unfair advantage would reduce or eliminate it. And so both parties should enter into the agreement of their own free will without undue influence or pressure. And so the case says the agreement is unlikely to be upheld if there is any evidence of duress, fraud, misrepresentation, or unconscionable conduct, such as the example given, which is exploitation of a dominant position to secure an unfair advantage. Paragraph 72 goes on to talk about a party's emotional state. And it says that a party's emotional state at the time of making an agreement is a relevant consideration, together with factors such as age, maturity, and previous experience of long-term relationships. Those factors may inform what pressures a party felt to sign the agreement. And in the case of a prenuptial agreement, the court may also consider whether the marriage would have gone ahead in the absence of an agreement in the terms signed. The next point to consider in terms of fairness is whether parties have a full appreciation of the implications of the agreement. So on this point, at the time of signing the agreement, each party should be in possession of all of the information, material to their decision to sign the agreement. And that means that whilst full and frank disclosure, financial disclosure is desirable, it's not necessary for a party to have full particulars of the other party's assets and income if the party is fully aware of the implications of the nuptial agreement. Independent legal advice was also commented on. It does provide strong evidence of a party's understanding of the implications of the nuptial agreement, although it's not conclusive. And so the parties should both intend the agreement to determine the financial consequences of the marriage coming to an end. In the case of Radmaker, however, the husband didn't take independent legal advice prior to entering into the prenuptial agreement, and nor did he seek or receive any information about the wife's financial circumstances. Despite this, in the Supreme Court, they were held not to be reasons for the court to refuse to uphold the terms of the agreement. And that point is made in paragraph 69 of the judgment, which says that sound legal advice obviously is desirable because it ensures that a party understands the implications of an agreement, but full disclosure of any assets owned, it may be necessary to ensure that. But it goes on to say, if it's clear that a party is fully aware of the implications and indifferent to detailed particulars of the other party's assets, then there is no need to accord the agreement reduced weight because he or she is unaware of those particulars. And what is important is that each party should have all the information that is material to his or her decision, and that each party should intend that the agreement should govern the financial consequences of the marriage coming to an end. Moving on then to the third sort of limb of the fairness test, which is this: it must be fair to hold the parties to their agreement in the circumstances prevailing. Now, fairness is always always subjective and is dependent upon the circumstances that prevail at the time. And so the Supreme Court in this case didn't set down any sort of specific rules to help determine this particular limb, but did give some guidance within the judgment. So, for example, at paragraph 77, it was noted that it isn't fair to allow a nuptial agreement to prejudice the reasonable requirements of any children of the family. In paragraph 78, it was noted that the autonomy of adults should be respected. It is paternalistic and patronizing to override the terms of an agreement simply on the basis that the court knows best. In terms of paragraph 79, it was noted that there was nothing inherently unfair about an agreement that seeks to ring-fence non-matrimonial property, including assets owned before the marriage and assets that a party anticipates receiving from a third party during the marriage through a lifetime gift or inheritance. In paragraph 80, it was noted that in general terms, the longer a marriage lasts following a nuptial agreement being signed, the greater the chance it may not be fair to hold the parties to its terms because of unforeseen changes in circumstances. And that's more likely to be an issue where parties to an agreement, for example, are a young couple starting married life with a few assets, rather than, for example, a couple who have been married previously, which each brings significant assets to a second marriage. In paragraph 81 of the judgment, it was noted that the strands of need, compensation and sharing identified in White and Miller are relevant considerations that might inform fairness and might apply as follows. So it's likely that to be unfair, it is likely to be unfair if the effect of the agreement is going to be that one party is going to be left in a state of real need whilst the other is comfortably provided for. Or if one party has a valid argument for an element of compensation, for example, where one may have lost earning power following a joint decision that the other spouse should give up a potentially lucrative career to look after the children, then an agreement that ignores compensation is also likely to be unfair. Another example given is if needs and compensation are adequately covered, then a nuptial agreement may effectively prohibit further sharing of the assets. That's a point that's made in paragraph 82. And now that we've looked at the case of Radmaker, I'm going to hand you back to Siân, and I'm going to stop sharing my screen so that Siân can cover the next section of this talk.
So I'm going to pick up there where Krishma stopped, and we're going to look here at the weight to be attached to the agreement. So as Krishma said, I'm dealing here really with the first limb. So that's going to be considering, is the agreement freely entered into by each party with a full appreciation of its implications? And that's the cornerstone bit of law in relation to whether there is a vitiating factor effectively, which might undermine the weight to be attached to the agreement or even eliminate it completely. And so we take from Radmacher and from Edgar, which was specifically considered within that case, that it's not necessary to think in formal legal terms about concepts such as misrepresentation and estoppel. We're really looking at all of the circumstances that can affect a couple who are in this situation. So what does that mean for what we might be looking for in cases, or looking out for in cases where there's a prenuptial agreement? Well, obviously, cases of duress, undue influence, mistake, misrepresentation, those classic set of vitiating factors are going to open the door to arguments that we're going to eliminate or try and reduce the weight. But we're also going to be looking much wider than that, as Krishma said, into the sort of unworthy conduct or the unconscionable conduct that might see a party being placed under undue pressure. And what is said in Radmacher and what the cases really teach us as we go through them is it's not just the pressures that might be put on a party by the other potential party or to the marriage or the spouse. It's the pressures that are surrounding that, and we can include considerations of someone's emotional state and vulnerability, as well as obviously looking at those important factors. What did they understand about the agreement? And that's where we're feeding in issues in respect of legal advice and disclosure. So looking on, that's exactly where we're going to start. So in cases where it's said that there hasn't been legal advice or disclosure, there's a number of cases which we can consider in relation to that. In relation to all of these factors, really trying to place the focus more firmly on the more recent case law that we've been seeing. This is a very case law heavy area of financial remedies, and there are many cases to choose from in relation to each of the factors that we're thinking about. But I've tried to focus more on the more recent case law so that we can see where we are at the moment. In relation to legal advice on and disclosure, we really pick up from the case of Kremen and Agrest, where it was said very clearly at that stage that if we don't have independent legal advice and full disclosure, it's unlikely to pass the Radmacher test. But really, since then, the case law has come away from that sort of strict description of the law and probably closer to the original Radmacher principles, which were along the lines that Krishma described, that legal advice is desirable, but it's not essential, and full disclosure precisely the same. And the courts are going to look at all of the circumstances to try and pin it back to that test to understand, was there a full appreciation of the implications of the agreement? So in Versteeg, which was a case involving a Swedish agreement, these cases involving foreign agreements, particularly in European countries where in Sweden is an example, there are some formalities in relation to the signing of a premarital agreement, but they don't require legal advice to be given. They don't require disclosure to be given, but they would be effective in that country. And the principle really that Versteeg established and which has been built on since is that is not going to undermine the binding nature of the agreement. And so in that case, the formalities that would have rendered the agreement enforceable in Sweden were met, and it was considered to be a binding agreement in this country as well, notwithstanding that there wasn't any legal advice underpinning it. Likewise, in the case of CMX and EJX, this was a case of Mr. Justice Moore a couple of years ago involving a French separation to bien contract, excluding sharing, but not excluding a needs assessment, in fact. And what was found here was that there was no specific legal advice, although advice was given by the notary. But when one looked down into the facts, the parties were well aware of the respective positions and they were well aware of the contract's implication, and they're very common marriage contracts in France. And what's made clear here is that it must be understood that these agreements are a significant step, and it's not going to be the case that the English courts are just going to unpick them because the couple happen to be dealing with their divorce here and have spent their married life here. V&V is another case dealing with independent legal advice. I'm not going to delve into that one, but I think it's helpful to have a quick think about HG and WB, which is another case of Mr. Justice Peel. This was an agreement that was not a foreign agreement, but was negotiated and agreed in this country. The husband was fully engaged in negotiations over a period of some months. He engaged with amending the agreement, went through an intermediary to some extent, and he was told to get independent legal advice. He didn't do that, although he said that he had within the negotiations. And again, the court found that he did have a full appreciation of the terms of the agreement, and also that it wouldn't be fair to consider that the contract was vitiated by his lack of legal advice when he'd represented that he had had that, and the wife had relied on it. But this was a case where it didn't adequately provide for the husband's needs, and so he was provided with a needs-based outcome in that case, although it was limited because of the fact of the agreement. And we're going to come on to consider how the courts do assess needs in cases where there is a binding, otherwise binding matrimonial agreement that is considered not to provide a fair outcome. So the next vitiating factor, potentially vitiating factor I want to talk about is undue pressure. And we'll revisit CMX and EJX just momentarily on that point. This was the French contract, and it was said that there was family pressure to enter into the contract. And what was said by the judge in that case is that effectively there almost always is pressures, emotions are running high, families can apply pressure. There's the pressure of keeping the prospective marriage on track. Often, of course, the marriage won't go ahead if the agreement can't be reached, because such is the nature of the discussions that the parties are having, and that's particularly so on occasions when family are involved. But you need to get up another step to get into the realms of undue pressure. These sorts of general pressures that are present in most cases are not going to take that case into the next step of saying that it's not going to be binding. So in this case, in fact, the court did find that the agreement was binding, as I've already said, but the agreement didn't address needs. And so the court was open to or able to deal with a needs-based award, which it did on a generous basis, because there was no reason for restricting that, because the agreement itself didn't seek to do so. We come on then to MN and AN, another case in which there was efforts made to convince the court that the agreement was vitiated by pressure. And that pressure in this case was described as the mother of all arguments, which took place during the course of the negotiations, about the negotiations, it seems, and following which concessions were made, it was said, on behalf of the wife, which meant that she obviously had felt under pressure. And what was found was actually concessions been made by both sides following the argument. There had been a cooling off period after that, negotiations had resumed, and both parties had very high-end legal advice. And the court made the point here that the parties must realise that it's a significant step to instruct top lawyers to prepare these agreements, and it's likely that they will be held to them. And in this case, the argument, although not ruling out that such an argument could be a vitiating factor in different circumstances, it certainly wasn't here. And it's quite clear that what was taken into account was sort of the cool, calm nature of the negotiations that afterwards went through the lawyers and were reflected on over a period of time. And so that agreement was upheld as being binding and also as being fair. And so there was no additional needs award made in that case. Next, we find a case where the court did find that there was undue pressure. This is AT and BT, and it's a case of Francis J. And what was found is really set out on the slide there. And it's an interesting case. In fact, negotiations had been going on the prenuptial agreement for some months, but prior to the marriage, but the agreement was signed on the day before the marriage. And Krishma is going to talk in a moment about the so-called 28-day rule and the timing of the agreement, how that feeds into the concept of pressure and free will. But in this case, the judge found that these three elements really served to confound the wife, and the pressure she felt from these was undue in the circumstances. And that was that she was 4 months pregnant. She'd had to leave what was a very well paid career in a private equity firm because there was a conflict with the husband's position. So she didn't have her previous career, and she was getting married the following day. Everyone was assembled, as it were, and ready to go. And although the judge didn't make any criticism of the husband, these weren't circumstances that he'd brought about, it was found that the fact of the pressure on the wife was undue at that time. And clearly one can see that perhaps if that agreement had been resolved and agreed and signed sometime earlier, it may have been more reliable in the judge's eyes, but that wasn't the case. And so he found that it would be wrong to treat it as a binding contract because there's a thread running through the principles in the case law about pressure, timing, and independent advice. And in this case, he couldn't hold that thread together. And in this case, what he said was that he wouldn't disregard it completely. It was part of one of the circumstances of the case, but it wasn't a binding agreement. And in fact, the wife was awarded an equal share of the assets in that case. So I think I've got two more points to talk about, three more points to talk about in respect to vitiating factors. The next is the question of coercive and controlling behaviour, and this was an argument that was put forward in the case of Chauhan and Lim in 2022. And what was found in that case, what was made clear in that case, was that yes, coercive and controlling behaviour could amount to undue pressure in the right circumstances. It would fall firmly within the Edgar criteria if it was proved and if it was relevant, because it would be undue pressure or the exploitation of a dominant position. It was comfortably within that paradigm and those principles. But in fact, what was found in that case was that there wasn't any coercive and controlling behaviour. And that the husband's behaviour effectively was not operative in leading the wife into the agreement. There was vulnerability on the wife's part, and this was a post-marital agreement. She was desperate for the parties to get back together and to stay together. And that was a factor to bear in mind in assessing the weight of the agreement. But that did sit alongside the fact that she had achieved her aims that she had set out in entering into the negotiations of the agreement, and it was her proposed terms that went forward. So with all of those matters hanging in the balance, the court went on to consider how much weight to give this agreement, and having ruled out the vitiating factor of coercing and controlling behaviour, the judge was quite critical of the time that had been spent on the issue. And this is a really important factor that we have to come on to consider in how we put our cases and which cases we decide to run. But the efforts to prove that the agreement was vitiated and set aside really led the wife to attempting to argue that she had a sound sharing case. And what was found was that her sharing case was essentially unarguable in any event because the assets were almost entirely premarital. So even had she been successful, her sharing case would not have been in any event. And so there was significant criticism for that, and the costs in that case had got really entirely disproportionate to what was achieved in the end. The wife's award was about 378,000. She had spent 403,000 getting there, and the husband 257,000. And so any claim that she might have had, including a sharing claim, were overshadowed by that. And in any event, her sharing claim was outweighed by her needs claim. So she didn't have the need to pursue it. So that indicates the importance of having some careful thought into what can actually be achieved, even if the agreement is set aside. The next point is about unsigned agreements. This is a reasonably straightforward case and brings us back to WC and HC. Having decided in that case that there was no undue pressure, this was a case in which Mr. Justice Peel found that the second of the agreements in this case, which was the post-marital agreement, was never signed by the wife. So although they had reached an agreement between solicitors following a without prejudice meeting, the terms had been agreed and said to be agreed in correspondence, that final agreement was never signed by the wife. And considering this, what Mr. Justice Field found most important was that the agreement itself specified that it would only be binding on the parties from the date of it having been signed. It would be unfair, therefore, for the wife to be held to it and found to be a binding agreement that was presumptively dispositive in the circumstances. But it wasn't completely put aside. So although it wasn't a Radmacher agreement, the court was entitled to take it into account as one of the circumstances of the case, and the terms were clearly set out. And so what Mr. Justice Peel attempted to do was assess an award taking into account the wife's needs, and the award that he came up with approximated that contained within the agreement, but was more generous to the wife and more fully, effectively dealt with her needs. The next case is not a High Court decision, so not an authoritative decision, but an interesting one nonetheless. And it's a case of His Honour Judge Hess, in which the court was tasked with considering the position of a party who had contracted Parkinson's, and having done so, entered into a post-marital agreement that effectively gave all of the assets, or 80% of the assets, I should say, the joint assets, to the wife. And this was part and parcel of a decision that had been made because he had had sex with a sex worker, and he had wanted to resume the relationship, and this was part of the agreement as to how it would be done. The agreement didn't adequately meet his needs. He gave up his substantial sharing claim, which was worth about 2.5 million, to take only about 1 million. And it, as I said, it wouldn't meet his care needs or his health needs or his housing needs when put together. So he sought a half share, even though his needs really exceeded that. And the judge, in considering this, was quite taxed to consider how the court should deal with a clause where someone voluntarily, and it was quite clear that the husband had legal advice, he had enough information, he went in with his eyes wide open and he knew what he was doing, but he had given up the right really to have his needs met. And also to consider, is there any difference here in a person giving away the assets to which he had a secure claim in the sharing claim, as opposed to in a premarital agreement, someone giving up the potential of that sharing claim in the future? And without really answering those questions, that's not a criticism of the judgment. The judge concluded that it'd be wrong to place weight on the agreement because it was very much to the husband's disadvantage, and he felt that the wife had been able to take some advantage of him in the situation. And so he was left in a predicament of real need, and the agreement should have no weight placed upon it. And so his claim should be determined in the usual way. Right, I'm going to hand over back to Krishma now, so that she can take us on to the next section.
Okay, so I'm going to talk about the Law Commission's 2014 report. So back in 2009, this is pre-Radmacher, the Law Commission started a project to examine the status and enforceability of marital property agreements, including prenuptial, postnuptial, and separation agreements. The project was originally called the Marital Property Agreements Project, but is now called it's now known as the Matrimonial Property Needs and Agreements Project, because the scope of it was extended during the consultation process. It was extended in scope and timeframe by significant events such as the Supreme Court's decision in Radmacher and the Family Justice Review Fund report in 2011. Now, the 2014 report, when it was published, recommended one, introducing qualifying nuptial agreements. They would be enforceable contracts which would enable couples to make binding arrangements for the financial consequences of divorce or dissolution. And in order for an agreement to be a qualifying nuptial agreement, there were certain procedural safeguards that would have to be met, that are set out. And qualifying agreements could not, however, be used, it was said in the report, by parties to contract out of meeting the financial needs of each other and of any children. The report includes a draft nuptial agreements bill which would introduce qualifying nuptial agreements in England and Wales, but the government's final response to the proposals are awaited, and including their response to the draft nuptial agreements bill also awaited. And so the extent to which Parliament may adopt the reforms proposed by the Law Commission remain to be seen at the moment. Moving on, in fact, we've actually covered this slide already. We just talked about the earlier slide, which is certain procedural safeguards which would have to be met. That's bullet point number 2. And this slide simply goes on to deal with what those procedural safeguards are. So, for instance, the agreement to be contractually valid, for it to have been made by deed, containing a statement signed by both parties that they understand that it's a qualifying nuptial agreement, that it must not have been made within the 28 days immediately before the wedding or celebration of civil partnership. That's something I'm going to talk about in a moment. That both parties to the agreement must have received, at the time of making the agreement, disclosure of material information about the other parties' financial situation, and that both parties must have received legal advice at the time that the agreement was formed. And what's also recommended is that it should not be possible for a party to waive their right to disclosure and to legal advice. Now, after this report, it became a general principle that prenuptial agreements should be signed at least 28 days before a wedding or celebration of a civil partnership. This effectively, it's to act as a safeguard against undue pressure, or at least against parties being suddenly confronted with an agreement at a point in the engagement where they may feel unable to say no or effectively negotiate. The report concludes the timing requirement will assist in mitigating pressure that parties may feel to sign the agreement closer to 28 days before the wedding or the celebration of the civil partnership. But there isn't a timing requirement for post-nuptial agreements. This is in relation to prenuptial agreements. Now, although the recommendations that are made within this report are influential, and they should continue to be adhered to when drafting a prenuptial agreement, wherever possible, the case law doesn't presently support the contention that execution less than 28 days in advance of a marriage or civil partnership will automatically invalidate the agreement. And I've set out a few examples that we're going to go through in a moment. And the examples effectively show that many agreements signed less than 28 days beforehand have been upheld by the court. So looking at the first example, 2014 case in the High Court, SA versus PA, Premarital Agreement Compensation 2014 Authority EWHC 392 citation. This was a case that involved an English wife and a Dutch husband. They had 4 children. Their capital assets amounted to about 3.8 million. The High Court in that case found that the prenuptial agreement was valid even though it was signed on the eve of the wedding ceremony, in circumstances where the wife was pregnant and only received impartial and not independent advice from a notary. In that case, the court was satisfied that the wife had entered the agreement freely with a full appreciation of the agreement's terms and implications. She was found to have been privy to all of the draft agreements, and even though the agreement in that case was written in Dutch, the wife had made extensive annotations on an earlier draft of the agreement in English, and she had also added some Dutch words to the declarations that the parties were to sign. The court found that the parties had intended the agreement would be binding upon them in all jurisdictions. And the only other significant factor in that case was the wife's claim for compensation, because in that case, she was saying that she'd given up her legal career to focus on the family. But the court was not satisfied in that case that the wife had met the high threshold for establishing a compensation claim. So that in that case, 28-day rule wasn't abided by, and the agreement was still upheld, and that was a prenuptial agreement signed on the eve of the wedding ceremony. I'm going to move on to another case which has already been touched upon, Veersteeg versus Veersteeg, 2018 Court of Appeal Authority, EWCA CIV 1050 citation. And in this case, the prenuptial agreement was signed just one day before the wedding. There were 3 non-minor children of the 21-year marriage. The husband was an affluent businessman. The wife was a homemaker. There were assets of some 273 million pounds. Both parties were Swedish nationals who had married in Sweden, and the prenuptial agreement was a contractual arrangement which stated that the parties would retain their own assets acquired before and during the marriage. Now, in that case, again, the prenuptial agreement was signed only one day before the wedding, but the Court of Appeal held that it was valid. It was, as part of the court's consideration, it was noted that it was a simple and straightforward document. And also in that case, the court accepted the husband's evidence, which was that the parties had discussed the binding agreement and its terms in detail several months in advance, whereas the wife had said that she'd only read the agreement upon separation and was shocked at its terms, but the court didn't accept her evidence in that case. So that's another example of an agreement that's not been signed 28 days before a wedding that has been upheld. Next case is another case that Siân has already touched upon, HD versus WB 2023 authority. And in that case, the parties were both aged 46. After a period of separation, the parties were engaged in 2003. They married in 2014. They shared 3 minor children whose care was shared between them both. The assets in the case, almost exclusively held in the wife's name, exceeded £43 million. There was a prenuptial agreement, and that was dated the 26th of July 2014, and that was the date of the parties' wedding. And in the case, the court was tasked with what weight, if any, was to be given to the agreement. The husband in that case argued that he hadn't understood the prenuptial agreement, and in any event, it didn't meet his needs. And the wife argued that the agreement should be upheld because it was entered into willingly, it had been understood by the husband, and it would fairly meet his needs upon realization of his business interests. Mr. Justice Patel in that case concluded that the prenuptial agreement was not vitiated. It had been freely entered into by the parties with a full appreciation of its meaning and its consequences. Ultimately, in that case, the prenuptial agreement was departed from on a needs basis, but importantly, noting the 28-day rule emanating from the 2014 Law Commission report, the court didn't hold it invalid, given that it had been signed on the date of the wedding in that case. It was also noted in that case that financial disclosure was, in broad terms, accurate, that the wife shouldn't be prejudiced by the husband not pursuing lines of inquiry. In paragraph 90, it was stated that whilst the husband didn't take formal legal advice, he had ample opportunity to do so. And therefore, a lack of legal advice was not considered a vitiating factor, or so fatal that no weight could be attributed to the agreement itself. And therefore, that's another example of where the 28-day rule, although recommended in the report, hasn't meant that an agreement that was signed on the day of a wedding was invalid as a result of the 28-day rule. There is then, I've put a further authority on this side, which is a case called Helliwell versus Entwistle, 2024 High Court authority. This is an authority that is currently subject to appeal, and I've made that clear on the heading of this slide. This is a case where parties were married for 3 years. There were no children. The wife's case was that she had assets of in excess of 61 million. The husband's case is that wife's assets were in excess of 74 million. Husband stated he had assets of about £850,000, although £500,000 of that was made up of a share of property in Spain, which couldn't be liquidated at the time. Wife worked for her father's company in Dubai and had income from all sources of approximately £600,000 a year. Husband asserted that wife, however, earned more at about approximately £1 million per year. Husband said that her husband didn't work at the time and said he was unable to. Parties in that case signed a prenuptial agreement on the date of their marriage, which provided, again, each to retain their separate property, any joint property to be split between them, and neither to bring a claim against the other in any other jurisdiction. The wife applied to have the prenuptial agreement upheld, and the husband argued it should not be enforceable because it didn't adequately cater to his needs. In the High Court, Mr. Justice Francis found that the agreement was written in straightforward, plain English, and that the husband knew exactly what he was doing, even though he had received very limited legal advice and financial disclosure from the wife. This is another case where, notwithstanding the 28-day rule recommended in the 2014 report, that the court held the husband to the terms of the agreement, although the court did accept in that case that the prenup did fail to meet his needs, and an order was made providing for a payment of £400,000 to the husband to meet those needs. Now, the husband, as I have said, has appealed this decision. The matter is currently within the Court of Appeal. The husband appealed on the following grounds. One, that the judge had not properly considered the husband's ability to seek independent and full legal advice in relation to the prenup, and the fact that the wife had pressured him not to do so. Two, that the wife had failed to give full and frank disclosure of her assets in terms of the prenuptial agreement, and that the wife's disclosed assets were nearly 4 times as much as that had been disclosed. And thirdly, that the judge had not properly assessed the husband's needs, and the amount payable to the husband was outside the reasonable band of discretion available to the court under Section 25 of the Matrimonial Causes Act 1973. The wife resisted the appeal, and the parties submitted their respective legal arguments to the Court of Appeal on the 19th of March 2025, and a judgment is currently awaited. And so what these cases show is that despite the customary guideline dictating that agreements should be formalised at least 28 days before the wedding, courts do acknowledge exceptions as evidence in this case law, and whether or not failure to adhere to a time limit will be fatal to the validity of a prenuptial agreement is going to depend entirely on the circumstances pertaining to the late signing. But it is worth practically speaking, to ensure that if you do have a client and prenuptial agreements are being considered, that sufficient time is allowed for the provision of disclosure, legal advice, and for negotiations to be conducted. And in complicated cases, for example, it can take a number of months to negotiate the terms of an agreement. So it's best to start early and not to leave things to the last minute, despite what the case law shows. So that's my sort of section on the Law Commission's report and the 28-day rule and application of that to some recent authorities. And I'm going to hand you back to Siân now, who's going to talk about fairness, court's discretion, and the application of fairness on needs in relation to prenuptial agreements.
So I'm going to start with just going back a little bit, just take us back to Luckwell and Lamata, which is really a helpful starting point when we're thinking, what is fairness? In what cases is the court going to say this premarital agreement is not fair? And in most cases, I think we know we're talking about needs. So this is where we start off, though. It's the court and it's not the parties that decides the ultimate question of what provision is made to them. In every case, including those where there's a binding premarital agreement, the court is conducting the Section 25 exercise and deciding what is fair. But the agreement itself is obviously capable of altering what is fair, including in relation to needs. So that's what gives us the clearest view that we may be moving the dial in terms of where the starting point is and where the end point is in relation to an assessment of needs if there is a prenup in play. So in Brack and Brack, the Court of Appeal, in a quite unusual circumstances, would have put in a position of being asked, is it just needs then that we're looking at here? Or if there's a premarital agreement in place, can an award be made on other bases, such as compensation and sharing? And what the court said in this case was it will usually be that assessment of fairness and therefore the award will fall to be determined on a needs basis. But that is not inexorably the case. And so there may be room, certainly for compensation cases, if that compensation might exceed the needs case. And very possibly in relation to sharing in unusual cases, this was a case which could have been that unusual case because there was a prorogation of maintenance provision which was found at first instance to exclude the courts in this country assessing needs, although as it transpired, that part of the appeal was successful. And so in the end, the matter was remitted for consideration on the needs basis that we're familiar with. So what is the assessment of needs going to look like? One has to think about what Krishma's already told us from Radmacher. Are we just looking at alleviating a predicament of real need? that's identified as a factor, or are we looking at something different when we're assessing needs? And really what the case law is telling us on this is that it depends. It depends on the circumstances of the case, whether you are looking to just get you over the line to having your needs met, or you're looking at something broader and more flexible in terms of needs. Every case will have its own facts, but the agreement itself may be a depressing factor and may bring the assessment of needs down to quite a modest level. In KA and MA, which is an important case on needs, Ms. Justice Roberts was considering parties in their second marriage, and there was a very restrictive premarital agreement in place, limiting the wife to just 600,000, notwithstanding the fact that there was a child and £20,000 a year in terms of periodical payments. And what the judge found there was that the fair assessment of housing and income had to reflect the fact that the wife had agreed to restrict the ambit of her financial claims. So although the agreement was unfair and it did not meet her needs, that assessment of her needs still had to take the fact of that unfair agreement into account in terms of assessment. But this is how they were assessed. So the husband was offering £750,000 housing and 20,000 a year per the agreement, index linked. The wife sought 2.3 million for housing and PPs to be capitalised, but from 150,000 a year. And Ms. Justice Roberts said that that claim would have been unremarkable if she'd been proceeding from a clean sheet. But as she wasn't, she assessed the housing award at 1.35 million and 100,000 a year. So you can see there was significant flexibility. It wasn't just about alleviating or getting oneself over the line of hardship. There was something more there, even though the agreement was tempering that assessment of needs. And that's emphasised again in the Ipecki and McConnell case. If you have needs, those needs are real. And if you can't meet them, then you are in a predicament of real needs. That's the position that's set out there. And then in HD and WD, which is a very helpful case, and it really helps to describe whether the types of circumstances that the court will take into account in considering, are you a person who's going to be just brought over the line of predicament of real need, or are you going to have a more extensive assessment of your needs? And the court will take into account all the usual factors, the length of the marriage, whether there are children, the resources, the nature of the resources, the extent of the resources, and the source of the resources, of course, lifestyle, contributions, and of course, the premarital agreement, even though, of course, it follows from the fact that the needs assessment's being conducted that it's been determined to be unfair. The next case, in fact, the last case that I'm going to address on the case of needs, but is a really important one, is a case of Mr. Justice Peel called AH and BH. It's a 2024 case. In this case, the wife didn't assert that there was a vitiating factor, but what she did say, targeting her challenge, I would say, is that the agreement didn't meet her needs. There'd been cohabitation and marriage for about 5.5 years. And what Mr. Justice Peel defined as being the principal issue before the court was the interplay between the terms of the agreement on the one hand, which purported to limit severely the wife's claims, and then the needs of the wife and the children on the other. And the resources at the time of the agreement, the husband had about £1 million in realisable assets, and a business worth about 45 million euros, income of about 132,000. The wife had about 670,000 of her own assets, which really represented her house, and she had a very minimal income that could almost be disregarded. The agreement provided that they would each retain their own separate property, and in the event that there were children, the wife would receive 600,000, and then another 200,000 for each year after 7 years had been reached, up to a maximum. And then there was inflation applied. The net assets at the trial, the husband had about 50 million in assets at the trial, and the wife's asset base actually had gone down. One of the reasons for that is that she'd invested some of the money from her property into the former matrimonial home, although that remained in the husband's name and wasn't up for sharing or any division under the agreement. So the fact that the wife forewent any entitlement to sharing was relevant, but the judge went on to consider, well, what has she given up? What would she have been entitled to sort of ground the analysis? And he put her 50% claim under a sharing claim would have been about 7.5 million. And so what was considered in that case was that clearly the court does have flexibility and a degree of latitude in deciding on the generosity or the frugality of the assessment of needs. And went on to consider in particular the way in which housing needs have been approached in cases of this type, and identifies, I've put up on the slide, the sort of 4 approaches that could be drawn from the authorities. So we've got the Schedule 1 type housing award, so you can live in this property until the children finish their education, and then it reverts back to the stronger financial party. There's the similar type award, but when the property is sold, when the children leave education, both parties get a share. So the applicant gets a share outright. A Martin style arrangement, which is effectively a life occupation of property, reverting only when the wife in this instance dies or remarries. And then an outright award with no reversionary terms, so purchase of a house in a suitable area to meet needs. And interestingly, what Mr. Justice Peel found in this case, having reviewed the case law, is that he was not aware of a single reported case where the primary carer of children with no significant assets had not received a sum of money outright for housing. So I think that would take into account numbers 2 and 4 on the list that we have here. He also noted that the courts have been happy to make awards of capitalised maintenance. And in considering the issues, he found, of course, that the agreement represents a constant influence on the case. The wife entered into the agreement sort of with open eyes. She understood the position. And she limited her claims. But on the other hand, she was the primary carer for the children. She'd put money into the house that the husband owned and wasn't really getting any thing back for that. That was to her disadvantage. Another important point was, although they had anticipated having children and they'd built in a review clause to be executed or exercised when the children were born, that had never happened. And that gave an indicator, of course, that there was unfairness, potentially understood to be unfairness in the way that the agreement operated. And so the outcome in that case was to sell the matrimonial home and give the wife about 57%, 2.75 million, no reversion to the husband. The difference in housing fund for her and the children, her alone, didn't justify it, and he also felt it wouldn't be fair to keep looking over her shoulder. She had a budget of about 385,000 per year, which was reduced down to 110,000 for her and 40 for the children for a period of 10 years. Her sharing claim would have been greater without the agreement, but also so would her needs claim. So she'd have had a justifiably greater needs claim, taking into account the usual factors of financial resources, standard of living, length of marriage, etc. But the agreement depressed that award. So those are the important factors in looking at cases in which there is going to be assessment of needs and where unfairness in the agreement has prevailed. And of course, we touched upon earlier the type of agreement where needs are not dealt with, such as in some French contracts. And in those cases, the door is open to have a generous assessment of needs because it hasn't been circumvented or bookended by the agreement itself, potentially. Okay, so the last couple of slides that I want to look at, because I know we're getting close to the end of our time, are the challenges to marital agreement. What are the challenges that might be brought by the other side or that we're seeking to mount ourselves? So to review, we have to look at, are there any vitiating factors, not just the classics from that we're used to and that we learned about over the years, but is there undue pressure? What are the circumstances of the parties at the time? One has to look quite closely at the detail. What disclosure has been provided? Is the agreement fair? Does it satisfy the requirements of needs and exceptionally compensation? And then what are we going to run in this case? Are we going to run a case that there's a vitiating factor, or are we better off running a case of needs or fairness? And that is going to be an exercise in trying to work out, is there any matrimonial property to be shared if I displace this agreement? Is there a sharing claim there, or am I limited to a needs claim anyway? Does the agreement allow for assessment of needs in any event, in which case can I leave it intact? And if not, how significantly do I think it will alter the assessment of needs if it's not disregarded? So all of those will have to be factors, because of course running a case on vitiating factor can be expensive, and if unsuccessful, could have consequences in costs as well, and some may be quite finely balanced decisions as to whether we think there is undue pressure or there's been sufficient understanding or disclosure. So I've set out a list here of things we can think about with our clients on both sides to understand, is our agreement robust? Can we defend it? Are we going to get the judge to say that it's binding? Or on the other hand, can we challenge it? And can we get home on putting it to one side and having a more conventional assessment of the award? And so these are all the factors that we've talked about as we've gone through. I'm not going to go over them, but a couple that I haven't touched on quite so much: whether the marriage would have gone ahead. That doesn't necessarily undermine the agreement if the answer is no. That's been made clear in the case law. Is there a heads of agreement? Because sometimes, although it might be said that the terms of the agreement, final agreement, are not understood, if there's a clear, more summary heads of agreement that sets out the main terms, that might be a more difficult argument to run. Have circumstances changed? Often they have. And have review clauses been implemented? And if not, why not? And then lastly, just to touch on the issue of procedure, is it a preliminary issue, or is it going to be dealt with in the conventional sense? Well, of course, if you have a binding prenuptial agreement, then the Section 25 criteria assessment is potentially going to be quite curtailed, and it may be quite a short discretionary exercise thereafter. But there is still a discretionary exercise. And so the preliminary issue hearing, if you do have one, to determine whether the agreement is binding, can only decide that it would be presumptively dispositive, and the court will need to have another hearing to decide the Section 25 factors. That was certainly the case in HJB and WPB. There may be cases where it's appropriate to have a prelim hearing, and there may be cases where it isn't. And in cases where it might be sensible, or where you have substantial assets and there's a lot of dispute over the valuations, you wouldn't need to go through the process of dealing with all of that unless your agreement is not upheld, and you need to then look at everything. But if your agreement is upheld in a preliminary issue hearing, you may avoid some of those issues of valuation that would otherwise have money spent on them. So it's a matter of working out the proportionality. Is it going to save costs to have a preliminary issue hearing or not, most likely? And then the very last case is just to note a case that recently had a preliminary issue hearing, which was to interpret part of the agreement in relation to chattels to understand what fell within and outside of particular clauses in the premarital agreement. And one might find that those sorts of interpretation cases, there are more to come of those, but that is something that may feature in a preliminary issue. So thank you very much for that. That is what we have to say on the question of premarital agreements today. I was just trying to find if I could unshare my screen. There we go, I could do it. So thank you very much for joining us for that. If there are any unanswered questions, or anyone does have a question, there's nothing in the chat that I can see, then please do feel free to email us. You can email them to events@42br.com, or, oh, I stopped sharing my screen, sorry, before I put up our email addresses. Never mind, on another occasion, you can always find them on the website. But yes, you can email us at events@42br.com. The recording will be on the website and YouTube, and it will be sent to you in any event. We're very grateful for any feedback that you'd like to give us. And the next session in this family law series will be a private law update. That's taking place on Thursday, the 19th of June, and the speakers will be Mark Challoner and Rachel Chan. Thank you very much for joining, and we hope that that's been useful. Bye-bye.
Bye-bye. Thank you.